Sometimes you know already which case or statute you want to look at. You might have the title or the citation itself. In that case, you can search for it directly by using advanced search. As an example, we can use the 2007 Supreme Court case Massachusetts versus Environmental Protection Agency. From the Wikipedia article, we can determine that the citation is 549 US 497. This means that the decision was published in the 549th volume on page 497 of the U.S. Reports, which is the official record of the Supreme Court. It's usually easier to find a case by citation than by title, because many cases might have the same title, but the citation is always unique. Once we have the citation, we can put it directly into the advanced search in the citation field. One thing you must be aware of is that the search defaults to only federal cases and legislation. So if you're searching for something that is state level, you would have to add that. So in the advanced search, let's find the citation field and enter the citation that we have. I'm putting it in quotation marks to ensure I don't get results that have just these numbers in any particular order. So of course we get the one result, which is the case that we're looking for. The results list includes a short summary of the case. Looking at the page itself, you can see that there's a lot of information. I'm going to explain what it all means and how it could be useful for you. The first thing to keep in mind is that not everything on the page is officially from the Supreme Court. That is to say, some of the information is provided by Westlaw for the convenience of the researchers. That information is not what you would cite in your paper, only what the court itself has said. Along the top of the page, you will see the citation title, the court level, the date of the decision, the citation to the official reporter, and some other citations. These are called parallel citations, and they are to unofficial case reporters. They're included because not everyone used to subscribe to the United States reports, but perhaps to some other publisher's content. Next is the full title, the docket number, which is the number that the case is given as it goes through the different levels of court, the date that the case was argued, and the date of the decision itself. The synopsis is a summary provided by Westlaw. It includes a short description of the case and what the court held. Again, this is not written by the court. It's a summary to make it easier to determine what the case is about and the outcome. Here, the Supreme Court reversed the decision of the lower court and sent it back to be reconsidered. This part tells you which justices wrote a dissent to the decision, which means that they disagreed, and why they disagreed. The next sections are the key numbers, which I mentioned in the previous video, are Westlaw's classifications of the areas of law addressed in the section. There is also a short blurb about what the court said on the subject. You can go directly to that part of the decision by clicking on the number. For example, number 4 has to do with whether the state of Massachusetts had standing to bring the suit. In other words, was the state of Massachusetts directly affected by the EPA's failure to regulate greenhouse gas emissions in vehicles such that Massachusetts suffered injury or a risk of harm? The summary says yes, but remember that this is a Westlaw summary, so you don't want to quote it. Instead, if you click on the number, it will take you to the precise place in the court's decision where they said that. So this part here is written by the court, and you can quote it and cite it. The next part is the syllabus. This is a summary of the decision that's written by the reporter of decisions, but not by the court itself. These green numbers represent page numbers of the printed volumes. The one with the double asterisks is from the Supreme Court reporter, and the one with the single asterisk is from United States reports. The syllabus is pretty long here, so we have to scroll a bit to get to the actual decision. Here it tells you which justice delivered the opinion, who joined in the decision, and who filed dissenting opinions. Then it names the attorneys and law firms. Finally, we get to the decision itself. Under Opinion of the Court, the decision cites all sorts of other documents, such as the United States Code, public laws, regulations, other court cases, as well as the petitions of the complainants, and where there are links, you can find the text of most of the documents on Westlaw. As I mentioned, Westlaw adds some other conveniences for the researcher. The table of authorities is a list of everything that has been cited in the opinion, and it also tells you how much depth the court goes into talking about it. Like, did they just mention it, or did they discuss it in any significant way? In some cases, you can access the filings of the complainant and the defendant, but not always, depending on what we subscribe to. You can see the history of the document, That is, the decisions of the lower courts and any related decisions. In this tab, you can see what other resources have cited this case, such as other cases and secondary sources like law reviews. It's especially important to look at how other cases have treated this decision. There is a specific tab for negative treatments of the case, meaning that another court has considered the opinion and did not follow it for some reason. It could be that the decision of the prior case does not fit or relate to the facts of the current case, or if the court does not consider it precedential, like in this first entry on the list. It's usually not a huge deal, but you have to keep an eye out if the prior case has been overturned or overruled in some way, which means that it's no longer good law and you should not rely on it. Nothing like that has happened here, however, but if it did, you would see that in the treatment column. And you would also see it on the page of the decision itself in the form of a red flag. Here's an example. Twining versus State of New Jersey, where in 1908, the Supreme Court had said that the Due Process Clause of the Constitution does not include a right against self-incrimination. But as you can see from this alert at the top, it was overruled by a 1964 Supreme Court case, which constitutes severe negative treatment. So anytime you see a red flag, you should check what the citing case says. If you have any questions about using Westlaw, please get in touch with me. My contact information is in the library guide for this course.